So since your acting career began in 1984, how have things gone for you? I mean, I haven't really seen you in any other meaningful roles. Do you feel that left out of the Hollywood scene? I'm a little lonely for this episode. So I have one of my favorite characters. Hi, honey, but I'm all alone on set. I think the first time, Max, since we started shooting these like 4 years ago, it's just me. And one of my favorite movies is Ghostbusters 1 and 2. And I think I've indicated this in another podcast that you've probably seen, is that it's in my office. So one of the questions I ask prospective associates or articling students is, what movie is that from? If they get it right, they've definitely got a leg up on being hired. So thank you for attending. I really appreciate it. I'll have some questions for you as we go along. So I got an interesting, a couple of interesting messages that seem to focus on how an analysis goes in a case of sexual interference involving a minor complainant. So a much younger complainant, and it could occur in circumstances of an allegation within a family context, or somebody who is a friend or more distant relative of the complainant. And what the question was focusing on is, how do courts go about an analysis? Not so much how you run your defense, but how does the court go about the analysis? So there's one recent case which piqued my interest, and we may actually put it into our next newsletter. It's Regina versus DD, 2025, ONCJ 355. It's a 𝐂𝐎𝐏 citation. And it's out of Sudbury. And I'm going to read a lot to you because I haven't been able to memorize it. But it's interesting because of the analysis that the judge provides in the actual statement that's played in court, and I'll explain that in a moment, and questions that are being asked by the officer that the judge considered to be leading questions, which detracted from the reliability of the child's evidence, and then also gaps in evidence about disclosure, which was a particular issue. And I apologize for doing this. I'm in the midst of managing a case. So this judge actually took interest in certain gaps surrounding the timing and circumstances of the disclosure of the child. And these two areas intersected in the judge having reliability concerns. So I thought that was very interesting, and I thought this would be a good case to illustrate how a court goes about its analysis. So let me just give you the factual background. So the allegations are alleged to have occurred between September 4th, 2019 and September 4th, 2020. The accused, DD, was alleged to have committed offenses of sexual interference and sexual assault upon his biological daughter, HD. So he was charged with 2 offenses, sexual interference and sexual assault. And by the way, if a person's convicted, they could only be convicted of one. The subject matter of the charge is the same, but they generally lay both charges. The judge concluded at the end of the trial that the Crown failed to prove beyond a reasonable doubt that the accused had committed the offenses with which he was charged. And in particular, the judge found that HD to not be sufficiently reliable as a witness. And that was for a number of factors which I spoke about. So just to set this up, when you have a child complainant and it's reported to the police, the child complainant will come into the police station and will be set into a special room, usually with investigators who are generally specialized in dealing with minors, and they will then take a video recorded statement. Sometimes in those circumstances there will be a member from Children's Aid present, because there would be a joint investigation, particularly if the accused is a family member, particularly a parent. And the interview is recorded, so it's video and audio recorded. Because the person is under 18 years of age at the time that they give the statement, the Crown can apply under 715.1 of the Criminal Code to have the complainant's video statement admitted as evidence at trial for the truth of its contents. And that's standard. And there are certain ways to try and prevent an application under 715.1 to be successful, but it's very, very, very narrow, and it's generally not a situation where a individual, an accused, will be successful in excluding a statement, even if you're able to point to some reliability issues with the video statement itself. So in this case, ultimately, the video statement was admitted as evidence for the truth of its contents, but the defense specifically took considerable issue with the weight that could be attached to it, meaning how much the judge could actually rely on it due to issues with all of the evidence in the case. And in this case as well, as it was a child, the child testified through closed-circuit TV, which is another issue, but you can understand in circumstances where you have a child in the family, it may be highly traumatic and not allow the child to give the full extent of the evidence if they're in the courtroom with the accused. So the central issue in this case was testimony of the child, testimony of the father. And the judge had to go through the typical analysis, which is the child's evidence sufficiently credible and reliable? The accused testify. Did the court believe the accused? And if the court doesn't believe the accused, was the court left with a reasonable doubt on any of the essential elements of the offense in consideration of the evidence? A truncated sort of version of what I'm going through now of what we've spoken about before, which is the WD analysis. And the court concluded also that at the end of the day, there was nothing in particular about the accused evidence that caused the court to reject his testimony. Now, further by way of background, the father was, as we noted, the biological father and had been the primary caregiver for most of the child's life prior to the allegations coming up. The allegation arose out of an evening where the father, along with the child and an older brother, were watching a movie together and fell asleep. HD alleged that she woke up to her father rubbing his penis on her lower back and buttocks and digitally penetrated her vagina while he lay behind her in bed. The Crown submitted that the child's evidence on the core facts were credible and reliable, and that any inconsistencies were immaterial when assessed in accordance with the jurisprudence involving child witnesses. The accused insisted that the incident never happened, and that there were countless occasions when they had fallen asleep after watching movies together as a family, but he had no memory of anything of this sort ever occurring. And the lawyer for the accused aggressively argued that the videotape statement should be given considerably less weight due to the repeated leading questions put to the child during the interview by the investigating officer. And additionally, the lawyer submitted that the testimony of the child in this case had material inconsistencies between her in-court testimony and the video statement evidence. And I think we've mentioned this before, that when the statement is introduced, often one of the fruitful areas of cross-examination, and sometimes it happens in examination in chief when the child's testifying, that there will be inconsistencies between the child's evidence when they're testifying in court versus what they actually stated to the police officer. And that can be a very fruitful ground of attack on the reliability of the child. In assessing the evidence, a judge, like any other case, has to assess credibility and reliability. And I've said this before on a podcast. Credibility relates to the honesty or veracity of a witness, specifically whether he or she is expressing themselves truthfully to the best of their abilities. Reliability relates to the accuracy of the witness's testimony. In determining this, the court must consider their ability to accurately observe, meaning the witness, to observe, recall, and recount the events in issue. A credible witness may give unreliable evidence. Accordingly, there's a distinction between finding a credibility and proof beyond a reasonable doubt. So a person can still appear credible to a court, but the case may not be proved beyond a reasonable doubt, simply because there are significant reliability issues. Let's talk about how a court assesses child witness evidence. First of all, in most cases, inconsistencies on minor matters are not generally significant. They are not matters that would generally affect a witness's credibility. Similar with a child. Inconsistencies on minor matters or matters of detail are normal and do not generally affect the credibility of a witness. However, one or more inconsistencies involving material matters can justify concluding that the witness is neither credible nor reliable. And in determining this, the court will look at the totality of the circumstances of the case and of the inconsistencies. I'm going to truncate what's written here, but they're going to go into a WD analysis as well, and we'll consider how you assess the evidence of a child. So this child was 11 years of age at the time of testifying. They were 6 at the time of the alleged offense, and I believe the child was 7 at the time that they gave the statement to police. Now, case law, and one of the more recent cases, Regina versus Barua, B-A-R-U-A, 2014, ONCA 34, and there's a case from Supreme Court of Canada called B.G., basically state the following, okay? Regarding the credibility and reliability of child witnesses, it seems to me that there was generally a suggestion that the judiciary should take a common sense approach when dealing with the testimony of a young child and not impose the same exacting standard on them as you would on adults. This is not to say that the court should not carefully assess the credibility of a child witness, and the courts do not suggest that the standard of proof must be lowered when dealing with children as witnesses. So that's important to remember. Rather, the court expressed concern that a flaw, such as a contradiction in a child's testimony, should not be given the same effect as a similar flaw in the testimony of an adult. While children may not be able to recount precise details and communicate the when and where of an event with exactitude, this does not mean that they have misconceived what happened to them and who did it. In recent years, courts have adopted a much more benign attitude towards children's evidence, lessening the strict standards of oath-taking and corroboration, and of course now we know there is no corroboration necessary in law, and the courts believe that this is the desirable development. The credibility of every witness who testifies before a court must of course be carefully assessed, but the standard of reasonable adult is not the necessarily appropriate standard when dealing with young children. And so the law evolved over time, and it removed any notion that the evidence of children was inherently unreliable and must therefore be treated with special caution. So that's one sort of discriminatory belief that was removed from the law. Therefore, the law evolved. The requirement that a child's testimony be corroborated was removed from the criminal code. That was abrogated a while ago. The second notable change in the law, and I'm just giving a bit of a history here and in the case law as well, that the law towards the evidence of children was a clear understanding that it would be wrong to apply adult tests in assessing credibility to the evidence of children. Justice McLaughlin went on to explain that children may experience the world differently from adults, and we should not be surprised that details that are important to adults, such as time, place, may be missing from the memory of a child. And so judges are instructed to take a common sense approach and do not apply the same exacting standards that they would to an adult. The case from 2014 mimics the exact same language. Factors that may have a decisive effect on the reliability of the evidence of adult witnesses, for example, material inconsistencies in details as to time and place, may play a significantly lesser role in assessing the reliability of the evidence of a child witness. Again, that is not to say that the child's evidence is subject to a less rigorous standard of assessment before it can be accepted in a criminal trial. Rather, it's to say that the assessment of the credibility and the reliability of any witness is to be tailored to the individual characteristics of the witness. Where the witness is a young child, age is one of those individual characteristics. Okay? So there are more cases. I'm not going to bore you, but there's a lot of other cases that talk about how we assess children's evidence. And it's important to talk about time and place because often that's sometimes a crucial factor. But children do not have the same recall with respect to timing. And as we discussed in another previous podcast, when we talked about the golden rule, there is flexibility with respect to a charging document as to what that time frame is. So there is a lot of latitude, particularly in cases involving children. So now, more important to this case, and I'm going to get into the real detail of it. The judge was very concerned about two things. One, there are a number of questions asked by the police officer during the course of the interview that either redirected the child, suggested what the child was referring to. So when the child was, in this particular case, referring to the movement of the father and rubbing something against him, the officer used the term penis. And the child said yes. That is highly suggestive. And although one might say that within the actual interview itself, it was pretty clear what the child was referring to, it was one of those examples of something that was highly suggestive. But in this case, the judge noted a number of times where the officer was highly suggestive and asking leading questions. And that had a very negative effect on the reliability of the child and on the statement. So the statement itself, when you view it, in and of itself, because of the leading questions and the suggestive nature of the questions, really negatively impacted its reliability. This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record, and now back to our podcast. Thank you. The judge, interestingly, also was concerned about gaps in evidence. And the judge found that the gaps in evidence that he was referring to, which happened in circumstances around the initial disclosure by the child, prohibited the judge from understanding the circumstances of the disclosure and a number of factors, which then made it very difficult to assess reliability. And this was interestingly expressed in this case, which is why I'm talking about it. So I'm going to quote from paragraph 39. There is a gap in the evidence that prohibits me from understanding the circumstances of the initial disclosure from the child as originally expressed by her that prompted the police investigation. This is a crucial component of information that would assist me in understanding the allegation in its most authentic form, including how and when it came to the attention of the police. It would also assist me in ruling out any possibility that HD was influenced in any way prior to providing her video statement to the investigating officer, particularly in this case when significant efforts were required by the officer to compel HD to speak of the sexual assault complaint. I'm also mindful that she spoke to the older brother about topics of sexual nature in a general sense. Several unanswered questions remain that are important for my analysis of HD's credibility and reliability. If he refers to actually the foster mother, or someone else had witnessed the initial disclosure made by the child, what did they do with that information? It's interesting that the judge was wanting to know about that. Who else was present at the time of the initial disclosure? What did the recipient say to the child in response to the disclosure? Who accompanied the child to the police station? What did the investigating officer or any other officer say to the child prior to commencing her video statement? What did any other trusted adult in HD's life say to her prior to her video statement? What did her brother discuss with her prior to the video statement, particularly of a sexual nature? Now, you may find information like this absent from other cases. It's not every case with a child complainant where the Crown will go through an exhaustive rendition of the circumstances of disclosure. Often it comes out naturally. You can imagine a child who makes a voluntary disclosure to a teacher at school or to a friend. The friend goes to the teacher, and therefore the teacher speaks to the child. And in cases like that, everybody's interviewed. And that evidence may be called at trial in order to give the circumstances of the disclosure, that it naturally come out. And the idea is the judge was concerned that there was a complete absence of any of the circumstances of the prior disclosure that would rule out any sort of influence on the child. Now, the judge paused to acknowledge that during the trial, HD explained that her brother influenced her knowledge of sex after the video statement, and that the two of them had suspicions that a woman by the name of Jamie was their father's girlfriend at some point when he cared for them. This is the same woman that the child says her father made explicit reference to during the commission of the sexual assault. I'm going to pause there. I'm not going to go into great detail about it, but the child had described in her testimony that, in fact, the father had been sleeping, had been saying things, and had made certain comments. The child had described virtually nothing said by the father in the video statement, then at trial had attributed a number of statements, including some reference to Jamie, which happened to be his girlfriend. But what is key is that what influence may or may not have been exerted by conversations with the brother may have either unconsciously or consciously influenced her when she gave her statement to police and ultimately gave her evidence at trial. So the circumstances with respect to how the disclosure was expressed by HD and whether there was any form of influence or suggestion is a necessary inquiry in this particular case because of the persistent and repetitive efforts made by the investigating officer on the video to initiate a discussion related to these allegations of sexual assault against her father. The probative value of such evidence increases when assessing the highly leading nature of the questions put to her by the investigating officer. So what the judge does here is the judge is particularly concerned about what influence may or may not have taken place of the child because the officer had to go to certain lengths in order to elicit evidence from the child in the interview. It seems that in this case, the child was reluctant to talk about the allegation against the father, and the officer had to use suggestive or leading questions. That, therefore, caused the judge to have concerns, not knowing what the circumstances were of the original disclosure, why the judge referred to what would be the authentic nature. And we know there's a case from a long time ago called Regina versus Kahn, which was a spontaneous utterance of a child after leaving a doctor's office to the mother. That was allowed to be admitted because it was spontaneous utterance of a sexual assault. And I won't go into the exact wording, but that was a very authentic, spontaneous utterance that the court could rely upon as stated by the mother, which is something that's not normally admitted, but it's the Kahn exception, and you can apply it. But the circumstances when the child gives the original disclosure does and can have a certain authentic quality to it, but also will give you good circumstances as to what other factors are at play. And the judge connects these two issues because of the leading nature of questions in the interview. So these gaps within the evidentiary record have adversely impacted my ability to fully assess and critically analyze the circumstances of how the initial disclosure came to light as expressed by her. Adding to my credibility and reliability concerns is the fact that the child was unable to recall who she first told regarding this incident. She thought she might have told her brother, but if not, she would have told her foster mother. She doesn't remember telling her foster sister. Moreover, the circumstances leading up to the child's video statement are vital for my assessment of credibility and reliability, as the judge will explain later, because she admitted to various leading questions put to her by both the lawyers that were directly inconsistent. So I'm just going to cut to the chase on this one. The lawyers there's the Crown attorney who didn't cross-examine but asked questions in examination in chief, and then there was cross-examination. Through that, there was a lot of inconsistencies between the in-court testimony and the video evidence. And therefore, there became this heightened concern with respect to these gaps in the evidentiary record about the initial disclosure. The judge spends a lot of time talking about the leading nature of the officer's questioning on the video statement, and as a result of that, in and of itself, finds that there are significant reliability concerns with respect to the video. And in fact, the judge found that there were various aspects of the video statement where the officer led the child on core sexual assault facts, and that was extremely concerning to the court. The judge found that the habit of leading questions put to the child in her video statement causes me great concern. The cumulative impact of the investigating officer's repeated leading manner of questioning of a 7-year-old child on key factual portions of her video statement effectively diminishes the weight I can attach to her evidence. As a result of these concerns, the weight to be attached to the child's initial complaint of sexual assault against her father in her video statement will be significantly reduced. So that, along with significant inconsistencies, and we're talking about material inconsistencies about in-court testimony that came out also in examination in chief and in cross-examination versus the statement, and those gaps in evidence that the judge referred to about the initial disclosure, led the judge to finding the accused not guilty. This is a very good sort of case study as to how a court can go about the analysis. It won't be applicable in all cases, but this was a good, unique one because of the leading nature of questions that the officer used. A lot of the time, police officers who are engaged in these types of investigations are highly specialized, and they know not to ask leading questions, but it happens. And so, you know, as defense lawyers, it's very important to pay careful attention to the video statement of the child. And it takes, you know, a number of times to go over that evidence because you can tease out certain manners of questioning and patterns of questioning that may actually lead to information that could be unreliable. And in other cases as well, I will say that even if you don't necessarily have leading questions by the officer, the circumstances surrounding the disclosure, not the timing, but the circumstances surrounding this disclosure can be a very fruitful area of cross-examination and then referencing in submissions, because that in and of itself may lead to certain issues about credibility and reliability, and maybe even tainting or influence. And you often see that in cases where the child is in the midst of a custody battle. I just want to say one other thing before I conclude this podcast. And we've mentioned this a number of times. The accused evidence was generally, I would say, accepted by the court. Didn't find anything that particularly led the court to conclude that he should reject the evidence of the accused. But the accused did say something about a lack of opportunity to have committed the offense. And I've cautioned about this before. So the child was not clear on identifying what room this happened in. And that's one of those factors that a court necessarily will give large flexibility to a child about. However, although the room identified on the upper floor by HD is different than the room identified by the accused, they both acknowledge that watching movies together as a family while lounging in bed or on a chair or a couch were commonplace in the accused's bedroom. He was insistent that the children would usually lay in his bed with their pillows and blankets and watch a movie. He recalled that he would sit on a lazy boy chair and passively do chores such as folding laundry or checking his cell phone. As it relates to the issue of opportunity, I find it hard to accept that throughout the material times, the child did not fall asleep in DD's bed. That's the accused bed. The same bed that he admitted his children would watch movies from with their pillows and cushions. I also find it hard to believe that without exception, these movies commence prior to bedtime as he insists. Not good. Maybe it was true in his circumstances, but all of us who are parents and have had children lie in our beds and watch movies, the timing is not always before bedtime. Sometimes it's a bit after, especially if it's on weekends. And to insist that the children did not fall asleep at any point, especially a 7-year-old or 6-year-old at that time, is not believable. It doesn't behoove an accused to suggest that there was no opportunity for this to have happened because they never fell asleep in my bed. That's just not realistic. And so my caution is that, you know, when we assess evidence and how we deal with it, those types of certainties or absolutes are not reliable. They are just not reliable because a child's going to fall asleep. And it doesn't help a person's credibility. It's much more credible to say, yeah, she fell asleep, I'm sure, a number of times because she's 6 years of age and we were watching it 8, 9 o'clock at night. Her bedtime is sometimes 9 o'clock at night, and she fell asleep by 9:30. Sometimes we were watching movies on weekends and it's past her bedtime. Far more believable, far more honest. And sometimes a witness will go, because they're on the spot in a sexual assault case, will say these things because they're so nervous about being convicted. But talking about the realities of what's truthful and what really happens makes somebody far more credible. Anyways, this was an interesting case. And, you know, looking at how an interview is conducted is something that has been, you know, a tool of the defense bar for many, many, many decades and years since we've been dealing with child cases. And this was a really good one to look at. So, you know, if you're curious about this stuff, again, it's Regina versus DD, 2025, ONCJ 355. It's on Cantley. And this came out of comments from a couple of viewers. So I hope I answered your questions and addressed certainly some of those issues. I look very carefully at the emails and the comments that we get, so please continue to send them in. I really like getting them. I want to thank my guest, Mr. Stay Puft. Thank you so much for attending. I really appreciate the company. Do you want to do pillow talk? You want to do pillow talk? No? You're too shy? Okay. So please don't forget to like, share, subscribe, and comment, as we love your comments, and thank you for your viewing. And we also want to thank 𝐸ZDNS for your continued support of this podcast. God bless you for supporting us, and you're a great service. Take care and have a good night.